5 seconds to go. Start. In our view, this is in ignorance of the observations made by this court in paragraph 28 of the first order, wherein this court specifically observed that right to bail in cases of delay coupled with incarceration for a long period should be read into section 439 CRPC and section 45 of the PMLA. The trial court in its order has held that the appellant individually and along with different accused persons have been filing one or the other applications, making oral submissions frequently. It further observed that some of them were frivolous. It was observed that this was apparently done as a concerted effort for accomplishing the shared purpose of causing delay in the matter. The trial court therefore rejected the contention of the appellant that he had not contributed to delay in proceedings or that the case has been proceeding at a snail's pace. However, in the very subsequent paragraph, that is paragraph 80, the court observed that in order to avoid any delay and considering the time being taken by the counsel for the accused in inspecting the unrelied upon documents, it had wide order dated 18th April 2024 put a query to the prosecution if the entire unrelied upon documents can be provided to the accused persons in a digitized form. It further recorded that the ED accepted the suggestion that it would expedite the proceedings. However, some time was sought to consider the same. A perusal of the compliance report filed by the Assistant Director of ED dated 7th May 2024, which could be found at page 757 of the paper book, would reveal that the Cyber Lab has informed that it would take 70 to 80 days to prepare one copy cloning of the data contained in the said unrelied digital devices. It could further be seen that though it has been submitted on behalf of the ED that hundreds of applications have been filed for supply of unrelied upon documents, the record would not substantiate the said position. Though various applications have been filed by different accused persons, insofar as the present appellant is concerned, he has filed only 13 applications in the CBI matter and 14 in the ED matter. It would reveal that some of the applications are for seeking permission to meet his wife or permission to file wakalatnama, to put signature on the documents, seeking permission to sign a check, etc. Most of the applications are for supply of missing documents and legible copies under section 207 and 208 CRPC. Some of the applications are of inspection of the unrelied upon documents. It is pertinent to note that all these applications have been allowed by the learned trial court. It is further pertinent to note that some of these orders were also challenged before the High Court, wherein stay was granted. However, a statement was made on behalf of the prosecution before this court when the first order was passed that the said petitions filed under section 482 CRPC would be withdrawn. The said statement is recorded in paragraph 27 of the first order of this court. We may state that when we specifically asked the learned ASG to point out any order wherein the learned trial judge found any of the applications of the appellant to be frivolous, not a single order could be pointed out. Stop.